From the main list, item number 1.
What is the matter about Mr. Khan? You're for the state.
Kitchen is the coke matter, Lordship. Coke plant.
Petition is cook.
Kitchen.
Yes.
Lordship, yesterday the state had made a submission that 39 coke plants were, and there's a Supreme Court order which said stay on the functioning. You know, may as well you can
Very
wait,
well.
you can wait for the main case, Lordship.
Since the other matters pertaining to the illegal mining of coal and illegal coke plants have been taken up by the full bench, let this matter also be placed before such bench.
Lordship.
Item number 2.
Lordship, in item number 2, this is regarding that, Lordship, in Trinidad matter, Lordship, this issue was addressed at length.
Yes.
If I
What is this?
transportation of coal, Lordship, they had raised some allegation. Weighbridge matter, Lordship.
Yes.
So, pre-Trinidad, there was a problem, Lordship. We'll have to admit state had a problem, but in Trinidad, Lordship, all aspects has been discussed in detail. And
No. After that, look at the CAG report.
Lordship, have you seen it, Lordship?
Then, what are you saying? The day we passed the order, the next day there was the CAG report. Non-functional weighbridges, the details are all mismatched.
We have put this in place and
No. Despite the state referring to an order dated August 23, 2023,
Lordship.
passed in PIL number 1 of 2022, it appears that serious anomalies in the functioning of weighbridges in the state and the abject failure to arrest overladen vehicles have been pointed out in a report by the Comptroller and Auditor General. Is it the CAG or the AG?
CAG, Lordship.
Full stop. Paragraph. In such view of the matter, the petitioner is given liberty to ascertain the deficiencies on the part of the state when the matter appears next 3 weeks hence. Full stop. The state will also furnish the relevant extract from the CAG report.
Lordship.
Yes.
We have filed our affidavit
Yes.
as respondent number 6.
Have you paid the costs?
Yes.
Thank you.
Oops, we had a-
Now it's admitted.
Any mention for unlisted matter? Any mention for unlisted matter? From supplementary list, item number 1.
Lordship, here there is a delay of 18 days, Lordship, in preparing the appeal. Lordship.
Yes, what is the matter about?
Here, Lordship, the private respondent number 4 and 5, Lordship, has filed a writ petition.
Private respondent number 4 and 5?
4 and 5 here in your Lordship.
Yes.
Filed a writ petition. The respondent number 4 claiming herself to be the daughter from the first wife of the pensioner, Lordship. Then the respondent number 5, Lordship, she also claims herself to be one of the wife, that is the third wife of the pensioner, Lordship. Now, Lordship, when the disputed question of facts were errors, Lordship, then the petitioner, that is the respondent number 4 and 5, has sought liberty to withdraw the writ petition, Lordship.
3rd of August order. It's not an appellable order.
Lordship,
It's not an appellable order.
Lordship, below there is a direction, Lordship. Next. I am not agreed with the withdrawal with the liberty to file a fresh before the cooperative civil court. My lord, last para, Lordship. Here I was getting the pension, Lordship. After the death of my husband, I was receiving the pension, Lordship.
All that, who's on the other side?
I'm appearing for the state
Who are
respondent.
the private respondents?
Lordship, I'm appearing for respondent.
All that, we'll modify that and we'll say that in the event the appellant was receiving the pension, he or she will continue to receive the pension, but that will be subject to the ultimate outcome of the civil proceedings. That's the only modification, because once the matter is dismissed as not pressed, then no order could have been passed on merits.
My lord, whether I was receiving the pension or not, Lordship, that is at pace, Lordship.
We are not going into that. We are saying if you were.
Lordship.
In view of the good ground shown, were you a party to the proceedings?
I was in the writ proceeding.
Report you were a party.
Yes, Lordship.
In view of the good ground shown, the nominal delay of about 18 days in preferring the appeal is condoned. Paragraph. Ordinarily, the order impugned dated August 3, 2023 would not be amenable to an appeal, since by such order, a writ petition filed by the respondent numbers 4 and 5
Yes.
was permitted to be withdrawn, and such respondents were given liberty to seek alternative remedy before a civil forum. Full stop. Paragraph. However, the appellant refers to the last paragraph of the impugned order, which provides as follows, colon. Set out last paragraph. Usually, when the court does not go into the merits of a matter and allows the petitioner before it to pursue the remedy in some other forum, no other order may be passed. Full stop. In this case, the court passed a kind of an interim order without there being a sequitur to the same, since the matter no longer remains in this court. Full stop. Paragraph. The appellant claims that the appellant was receiving the petition with the pension in respect of the deceased employee prior to the writ petition being filed and even prior to the impugned order being made. Full stop. The appellant says that the appellant is seriously prejudiced by the last paragraph of the order. Paragraph. The appellant is substantially justified. Full stop. The best course of action would be to modify the direction contained in the last paragraph of the order impugned by providing that in the event the appellant was receiving pension in respect of the deceased employee prior to the date of the order, the appellant will continue to receive the same, without prejudice to the rights and contentions of the fourth and fifth respondents herein.
Yes.
Full stop. Further, the receipt of such pension by the appellant will be subject to the outcome of the civil proceedings that may be instituted by the respondent numbers 4 and 5 herein. Paragraph. Appeal number so and so is disposed of on the above basis and without any order as to cause. The miscellaneous application is disposed of. Yes.
Item number 2.
Yes.
Maybe please, Your Lordship.
Yes.
Your Lordship, this is the case that the Modi Ganga, that Lordship, prosecution raised the law point, Your Lordship, that in fact, Your Lordship, what happened, although I'm in leave on Your Lordship, and today also at 11:30.
A long time, Mr.
Long
Mantu.
time.
That's why we had required even the previous time when we had adjourned it for a long time
Yes.
for alternative.
I'm deeply obliged for accommodating.
Please do not embarrass us. Yes.
Yes, Your Lordship.
We completely sympathize with you. What we meant that someone else could have done it.
In fact, I request the client, but
Yes.
they insist.
Very
upon
good.
me.
They have confidence in you. Very good.
So,
Yes.
Your Lordship, that Modi Ganga, that I want to differentiate, that
Yes.
this is why the manner of taking confidential statement, recording confidential in Modi Ganga is a judicial magistrate. But here it was purely an executive magistrate.
That's nice. That doesn't make a difference.
So, Your Lordship, that the mandatory requirement of one
Tell us the facts. We don't know the facts.
fact is, Your
My learned brother doesn't even know anything.
fact is what Your Lordship, that
Start.
the deceased husband, he came with one non-tribal to give 50 paisa and ask for divorce from the wife. That's what happened. The custom is that 50 paisa has to be given by a non-tribal to the wife to say that I divorce you. She refused to accept it. Then therefore he asked for a cup of tea. She refused to give that. Then he kicked her. That's what happened. Then he chopped the child who is eating rice, 4-year-old, 3 times, one on his head and the neck. Then thereafter, the daughter was also cut. Then the wife helplessly saw the husband run away. She took her dog and she wanted to cut herself. That is the case. Your Lordship.
She wanted to cut herself.
Herself. Then her brother saw from outside, came rushing when the commotion came up, then took the dog away. That's the statement of the brother.
Very good. So you are appearing for the husband.
No, I am appealing for the wife. She has been convicted on the basis of 164.
No.
Yes.
Husband
Husband died. Husband died and the son died.
So the wife killed both of them.
No. The husband killed the son
Yes.
and attacked the daughter also. Daughter is less than 2 years old.
Very good.
Then the wife seeing both of them collapsed in the kitchen, then she took the down and wanted to cut herself. And after
How
doing
did the
that,
husband die?
that's unknown. Even the wife didn't know the husband died. That was the case.
So the wife is accused of killing the children,
Killing the husband.
killing the husband.
Husband and injuring the daughter.
Yes.
That is the
So wife, what is the wife's statement?
statement under 164 has been said to be recorded, but in 313 she denied it.
What is the statement under 164?
Statement said that he came, he asked for divorce, then he chopped my son, then in the process she also took the dog and she hit him. That's all.
All right. Very
That
good.
was the confession statement.
Very good. Now, when was the confession recorded? 164 recorded?
164 recorded straight from, suppose she was arrested on,
Very good. When was it recorded? We understand that it was recorded, your case will be, it was recorded in the police station.
no, recorded on 2/4/2003.
2003. When did the trial commence?
Trial commenced in 2013.
2013.
13.
When was the 313 recorded?
313 recorded, Your Lordship. I said just 84. On 3rd March 2020.
March 2020. So the 164 was recorded, as you say, on
On 2nd 4/2003.
2003.
3.
From 2003 to 2017, there is no retraction.
No.
And the retraction comes only then. How much should we believe?
Retraction come only on the 313.
Only on 313.
313.
So why should we believe it?
So,
Retraction in 313 is not an effective retraction.
true, your lordship, but this situation tells that she didn't even receive the copies of the confessional statement. No copies were supplied to her. 207.
Where is it? Where is your argument in the trial court that no copy of confessional statement was supplied to
Yes. No, that prior to the argument was not advanced there.
Then
After
why should we
verifying the
accept it?
records,
Under 207, all papers are supplied. Where is the 207?
207, your lordship will see the order sheet of 131205.
Yes.
If the order sheet comes.
Is that the accepted position, Mr. Khan?
Lordship, we have to verify from the record. I haven't-
No, even the record speaks. I have checked it from the records.
Just show it to them. Show it to them. Because that 207 will record what all documents have been given and should record the 164 statement also. You are now fit.
Not fit, your lordship, at 11:30 I have appointment. I have to show the ultrasound report and do the
Very good.
dressing.
So,
No, little time, I'll
no, when will you? Because this has to be checked up.
yes,
This has to be checked up.
yes, yes.
When will you do it then?
Lordship will check the record properly.
Yes, take the records, see the records. Because if that is the case, then of course,
Yes.
it's a different matter.
Totally different matter.
Totally different matter. If she was not given that, then we have to give credit to her 313.
Correct.
Otherwise, no. When will you do it?
Lordship, next week or after 10 days, your lordship. because I have to-
I have
next
to
week,
finish this matter.
next week, any date, your lordship.
Next week, any date. So, very well. 3rd October,
Doubt.
since the parties need to check the lower court records, particularly as to whether the confessional statement of the appellant was made over to the appellant in course of the exercise under section 207 of the Criminal Procedure Code of Criminal Procedure 1973, let the matter appear of weekends, October 3.
And
Thank you.
apart from that, your lordship, under driving here, white ink has been used in the confession without any
Those
issue.
are things that you
Those are
show.
things.
Those are things that you
Yes.
show.
Just,
If
I
you
have
can
seen.
demonstrate, that
I say
that
like-
statement is something which is not reliable, we won't rely on it.
Deeply authorized for accounting.
Because otherwise also, in sentencing, we'll have sympathy for the wife.
Yes, such. Deeply authorized.
Yes.
From the main list, item number 1.
Please, Your Lordship.
Yes.
It's a copy of the report, Millets, has been made over to us. It's a perusal of the report would show Millets the report is neither here nor there. Because on one breath, Millets, they say that the work in package 1 has been allotted to a certain firm. And the first line of the report says, Millets, that NHIDCL is in the process of assessing the land requirement in the army area and the other areas. State government will be apprised what area is going to be required.
Yes. We made it very clear to
Well,
them that whatever trees have been felled,
Well,
can't be done.
Millets.
And can't be undone. But they must be ready to start work before the next tree is felled. We are not really, that's your interest.
Millets.
We are not really going beyond that because this is a matter which is lingering for a long time and we will confine ourselves to that part of it.
Well,
And when the project matures, then we will look at the project, its implementation, ensure that, it's properly done.
Well,
But right now, we confine ourselves to that.
Millets.
It is submitted on behalf of the petitioner, it's submitted by the petitioner, appearing person, that the status report filed on behalf of the state does not clearly indicate that the work on the first phase of the Shillong-Dowki Road project is about to begin, is ready to be commenced. Full stop. Paragraph. According to the petitioner, even though the report speaks of the work having been allotted to a private contractor, the report indicates that National Highways Infrastructure Development Corporation Limited would look into the availability of the land for such phase of the work from the land under the occupation of the defense services, and would also consult the state as to any additional land. Full stop. The petitioner submits that if negotiations and discussions are yet to be completed in such regard, it cannot be said that the first phase of the work is ready to be commenced. Full stop. Paragraph. For the moment, the court's interest is confined to the grievance indicated in the petition, to the effect that several trees have been felled in the rules that the project will get underway, but it is often the case that such projects are not ultimately undertaken or completed. Full stop. There is substance in the petitioner's apprehension. Full stop. As directed earlier, no further felling of trees should take place in Shillong or in respect of the area covered by the first phase of the work without actual construction work being ready to be commenced. Full stop. At any rate, NHIDL, IDCL and the state should report to this court as to when work is actually about to be commenced, whereupon appropriate leave may be granted to fell the requisite number of trees, to the extent absolutely unavoidable. Yes.
Item number 2.
Lordship.
My lord, I have received the copy of the.
Yes, Mr. Siddiqui.
I have received the copy of the petition. I am for the petition, my lord. So I have
Yes.
received the copy of the affidavit in opposition.
Yes.
I seek some time to give my
Very well.
result.
Since the petitioner seeks time to deal with the affidavit in opposition, let the matter stand over for 3 weeks. Affidavit in reply, if any, may be filed within the next fortnight. Yes.
Item number 3.
Same order, my lord, will carry on this.
Same order.
Same order.
Are you obtaining it?
Yes, Your Lord.
We'll rely on the same affidavit that we have filed in this matter.
We are yet to receive the affidavit and report.
We'll supply it, my lord, right now. We'll supply it.
Give it just now, because we have passed an order where
We'll do it, my lord. We'll
we'll
do it.
ensure it is done. Yes.
Item number 4.